All right, go ahead. All you.
Ladies and gentlemen, are we live? Ladies,
Yeah.
What's happening?
You were about to tell me a story, and you said you wanted everyone to hear it.
Back when I went to the tap house for lunch on Fridays, there was a time when it was like the same bartender, because I'd sit in the bar area because you didn't need to wait for the server to take you to a booth or something.
Mm-hmm.
And I was like listening to a video about the case, and she was like, "What are you listening to?" And I'm like, "Oh, it's this complicated case. It's crazy." And she's like, "What is it about?" And I'm like, "We don't have time. I don't have time to tell you what it's about, you know." And she's like, "Oh, I don't care. And, you know, there's nobody else in here yet." And I tell her about the case a little bit. I do the, 3-second summary.
3-second summary. Wow. Good luck with that.
Whatever, 3 sentences or whatever.
Not what they're calling it these days.
And I remember, like, I came back with a friend later, and it was after the Mata ruling. And I was like buying my friend lunch or something. And she was there and she was like, "What happened with that fake twin lady?" And I'm like, "Oh, well, they found she has to pay the guy $120,000 for her." And she's like, "Yes." It was so good.
Like, good news. They're having siblings.
It was so good.
Yeah, I don't know how we got off on a tangent there. I guess somebody here said Lauren has great teeth.
Sometimes your dentist wants to know how the case is going. That's the key. That's the point, I think.
I don't know why somebody said I had great teeth. Thank you, though. And then also Bruce asked if that was my dentist. I said no.
That is your dentist.
I wouldn't tell my dentist about my YouTube, or they would know how filthy my mouth actually is.
Your dentist is just using a fake name on YouTube for privacy reasons.
There's no reason to be private here. I mean, I'm not going to judge you. So whatever. Dentist stalking me would be like way less weird than anything else that happens during my day.
Yeah.
So, yeah. All right. Anyways, I guess I already had this pulled up. I forgot to put it away, but we're doing this new filing by Mike. Of course, Omar wrote it on his behalf, and this is in response to Laura. I think both asking for to proceed by declaration, and also she wanted it sealed. If I got that correctly, I only skimmed over it, but also, yeah, guys, Clayton's going to be on it on Megan's tomorrow, so that's definitely something you want to check out.
I put it on my calendar.
I don't even have a calendar, bro.
We have a lot of work to do.
So much work to do. So this is proof of life, guys, but I can't deal with the bright light on my face right now, so I'm going to turn the face cam off. But just so you know, I'm alive.
Crank the lights up. Whoa.
Okay. I got a new camera. I got to set it up though, and that could take I could take a week before I'm motivated enough to do that. So, all right, this should be fine. Give me 1 second. Okay. If I don't watch the.
Can we see the title of this real quick, just for context?
Yeah, if I don't watch how much light I'm exposing myself to outside of work because I have to stare at a screen for work, I get red eyes and headaches and shit. So,
do you take vitamin D?
No, I probably should.
Yeah. When I was in Oregon, they were like, "You live in Oregon, so you need vitamin D."
Yeah. Well, I mean, I live in Florida.
I want to read the title.
Oh, sorry. I thought you got it already.
Okay. We've got the opposition to petitioner Laura Owens' motion to proceed by declaration and waive live testimony. Okay. So she wanted to just say, "Trust me, bro. Here's my declaration. We don't need any live testimony."
I mean, that kind of shit usually works out for her when she asks for it.
Right?
It's not like she's ever been told no.
That's very similar to this Gingras thing of this case is this paternity case is very easy. This DVRO case is easy. Should take 15 minutes, right? Just trust me. Don't look behind the curtain. Mm-hmm. That's their modus operandi.
Right. Bushbirds, hey, what's up? Thanks for stopping in, guys.
Awesome.
I don't know if you know them, but they're really funny.
Those cats crack me up.
Yeah. All right. So here we go. Petitioner Laura Owens has a documented history of fabricating allegations of pregnancy, domestic violence, sexual assault, lying under oath, and presenting false evidence to the court. She's currently facing 7 felony charges related to serial pregnancy, fraud, and perjury in the Superior Court of Maricopa County in Arizona. It's including allegedly injecting herself with HCG. I mean, we kind of saw this in the last one, so they're just kind of restating this stuff. Let's see.
What's that footnote? There's a footnote.
Up here? It was just talking about the judgment.
No, the HCG footnote.
Oh, it's down here. Yeah, just talking about what HCG is.
Oh.
And how it means she was definitely absolutely pregnant, and there's no other explanation for that whatsoever, possibly.
And, this is important because if you are pregnant, then you will have HCG.
Right.
But if you have HCG, that does not imply necessarily that you are pregnant. This is an important logical distinction.
Yeah.
And I'm glad they put this footnote in the correct format.
Yeah. All right, let's see. Okay. Including allegedly injecting herself with HCG so she would test positive on pregnancy tests. Her latest filing in California, seeking a permanent DVRO against respondent Mike Marraccini, is the latest in a series of escalating behaviors abusing court processes as a means of silencing her victims to prevent them from combating her fictitious victim narrative. I like to call it victim fan fiction, but same thing. I mean, she probably does sit there and writes out little fan fiction scenarios of herself as a victim. I believe that. I think she probably has a bunch of diaries. Now that she can't post on Medium, what I would give to read those diaries.
You think so?
I'm sure. What do you think that she's just sitting there and just well, I guess I'll mind my business then? No, she's got to be sitting there writing a manifesto.
Oh my gosh. That is wild.
Yeah.
I mean, we've seen, when she does text messages or these emails, like the supposed email she sent her mom, right?
Yeah.
These things are huge. It's a lot of writing.
Yeah.
I wonder if she's writing emails to her sister or something. You know what I mean? That's kind of like a diary.
Yeah.
Something like that, right?
So I don't know if you might remember this. A lot of people might vaguely remember this. Steve brought up this other case in Arizona a long time ago. It was over a year ago. When he brought it up. I mean, the thing happened in 2018, but there was this lady in Arizona who sent 100-something thousand texts to her victim that she was stalking after one date.
Oh my gosh.
And he was like, what is wrong with women in Arizona? And I actually happen to know that girl.
That's right. I think you told us about this a long time ago.
Right. It was kind of a sad story. She was actually just very mentally ill. And she, when I met her, this was a little bit before this break happened. So she just stopped taking her medication. So I kind of saw her move from being a normal functional person who you could tell she was a little bit eccentric, but she was harmless, into this completely delusional person who was just spiraling out of control. At some point we lost touch, and then I see her mugshot all over the news several months later.
Oh.
Yeah, I don't know. And so I remember no matter what you say to somebody who's in that kind of state, no matter how much you try to reason with them or if you try to be there for them or whatever, you cannot fix that. So I gotta think that she's over there stewing, somewhere doing something. I don't know exactly what it is, but it's something destructive. Obviously, sending that email to Dave.
Yeah.
So there's no way that she's just sitting there behaving and not plotting something.
I mean, I think there's a YouTube account or two that she's posting sometimes comments under.
Yeah. I remember that. You told me about that one.
And I know there's other trolls out there, and those aren't Laura or whatever. Or
it's the internet, of course.
Rude people or whatever they are.
Yeah.
And, but I think there are some that are probably her. Yeah.
Well, I mean, it's really hard to. You can't really get through to people like that. Only a medical professional can get through to people like that. So unless she's finally decided to seek consistent medical care, which I don't know, man. She's got a lawyer who actually convinced her to stop writing online and stuff like that. Maybe he did tell her that going to see somebody and documenting that would be good for her case. Maybe she is. I don't know. But if she's not, then there's no way in hell she's just sitting there behaving and waiting for trial. So, because there's nothing you can do, no matter how much you care about a person or how hard you try, there is nothing you can do, nothing an ordinary person can do to stop somebody from that snowball from rolling down the hill. You know what I mean? So I've been there. I've done that. You can't.
I mean, now that Jinger's dipped out, maybe she's busy trying to write some filings or something. I don't know.
God knows where he is. Man.
Or staying busy at the gym, which I would think is expensive given that her family's filing for bankruptcy.
Right.
But,
well, I don't know. What I'm thinking is she said in her filings in this case when she's trying to get it sealed and all that about her anorexia and all these conditions that she has. I'm well, you better be, again, documenting treatment then. Not just that you have it. Don't just go to the doctor, report on your medical history that you have it so they'll write it down. you better actually go get treatment and get documentation to support that. So I hope that she is getting help somewhere.
Right. Yeah, real independently verifiable diagnostic information,
Right.
treatment information.
Yeah.
Not just, potential arts and crafts.
Mm-hmm. Yeah. All right. Let's see. Owens and Marraccini met in March of 2016, engaged in an on and off again relationship, ended in August 2017. During the relationship, Owens crafted a series of escalating narratives to emotionally manipulate Mike Marraccini. This included fabricating pregnancies, miscarriages, abortions, and fraudulently creating documents to support an ovarian cancer diagnosis. Owens used these traumatic fictions to coerce Marraccini into a dating relationship. For example, she used a fake/forged letter from a cancer specialist to encourage Marraccini to be more supportive of her, which again we went over this like last week, but again that was ridiculous. Doctors don't write like that. They don't talk like that. It's not a thing. All right. Things became tenuous on January 7th, 2018, when Owens confronted Marraccini and his sister in public, yelling and screaming obscenities at him. 2 days later, on January 9th, Owens obtained her retaliatory domestic violence restraining order in the Superior Court of California. The allegations in the DVRO were supported by photographs from injuries sustained in horseback riding, claiming that it arose to such a degree she had to seek inpatient mental health treatment, an allegation now suddenly missing in this latest filing. On January 22nd, Marraccini timely filed his DV-120 response and denied all allegations made by Owens, and noted her history of manipulative conduct, including her fabricated pregnancies and conflicting medical claims. Owens and Marraccini both submitted supplemental declarations and third-party witness statements. A hearing originally scheduled for January 26 was continued for further evidence, depositions, and declarations. Ultimately, on or about July 10th, exhausted by the false narratives, Marraccini entered into a stipulated agreement resulting in the issuance of a 2-year Kletz reported restraining order after hearing under Family Code Section 6200 without any admissions of wrongdoing by Marraccini. That order was set to expire on July 10th, 2020. Notably, there was never any finding that Marraccini ever committed an act of domestic violence. On the date the order was set to expire, Owens filed a request to renew the DVRO, alleging continued fear and allegations of various violations by Marraccini, which he affirmatively denies. A hearing was held on September 11, 2020. Despite Marraccini's objections and without a finding of new abuse, the court granted a 5-year renewal. Between 2022 and 2024, Owens used the DVRO as a means of advancing a fabricated narrative that she was a domestic violence survivor. She made multiple public statements, including a January 2022 TED Talk and a June 2023 Chicken Soup for the Soul essay, all of which accused Marraccini of engaging in abuse. And that Chicken Soup for the Soul essay has been removed from their online publications. In the 2020 hearing, was this when she claimed that he was at like a Barry's location near her or something when I think he had some sort of location data that could have, refuted that. I vaguely remember that. I don't know if you do.
Yeah, I think Schnitzel Ninja has more details on that.
Yeah, she was busy tonight, but yeah.
There was one instance where, yeah, he had some sort of proof that he wasn't even in town or something like that.
Right.
The other one was the one where, he was visiting his sister and she was screaming at him. And
right.
I think that was earlier though.
Mm-hmm.
Because that was the original, not the renewal. I think the renewal was more fabricated instance of saying that he was near her or something like that.
Right.
And it's crazy because back then, right, they lived in the same area, but now she lives in Arizona and he still lives in California. So this is just, why do you need a restraining order on somebody states away? It doesn't make sense.
Yeah.
A lifetime restraining order. That's just
nuts. Right, let's see.
Yeah.
Meanwhile, Owens continued to use her pattern of falsifying pregnancies with 2 new victims in the Superior Court of Maricopa County. And we pretty much read, if not the same paragraph, similar in the last filing we read. So I'm going to skim over this and just get to like the Mike stuff. Let's see. Litigation with Mr. Eckerd went to trial on June 10th. We knew about that. The court found Owens was never pregnant by Mr. Eckerd and granted his request for a finding of non-paternity. The court found Owens had acted unreasonably in the litigation, initiated litigation without basis or merit, provided false testimony, and that Owens' petition was fraudulent and made to incite communication, a relationship, or both with Mr. Eckerd. She was ordered to pay over $148,000. Okay. On May 6th, Owens was indicted by a Maricopa County grand jury on 7 felony counts, including fraudulent schemes and artifices, perjury, forgery, and evidence tampering related to the action with Mr. Eckert. Okay. On July 10th, Owens submitted a second request to renew the restraining order, indicating her intent to seek a permanent order of protection against Marraccini, largely due to his attendance at the Eckert trial pursuant to a lawful subpoena. On July 23rd, Owens filed a motion to proceed by declaration and waive live testimony to silence Marraccini in furtherance of crimes she's currently being prosecuted for in Maricopa County. This newest abuse of process constitutes witness intimidation in violation of, what is PC? Section 136.1. I don't know what that is. I'm no lawyer, so, all right. Owens' bid to avoid live testimony is an affront to fundamental due process and a disgraceful ploy to shield her chronic falsehoods from cross-examination. Owens' current felony defendant, of 7 felony counts.
Should be penal
conduct.
code.
Okay, gotcha.
Because it would be criminal witness if you proved it. It would be criminal witness intimidation,
okay.
as opposed to family law.
Okay.
California Family Code.
Yeah. Oh, people are trying to get Bushbirds caught up in the chat here. I think somebody's mentioning the tight email. That is never going to go away, is it?
I always recommend, if people want to ramp up on the case, to watch the 3-episode interview with Dave Neal on the Off the Vine podcast with Caitlin Bristow.
Yeah, that was a good one.
That 3-part interview will get you caught up. I mean, it's not like 30 minutes, but it'll get you caught up.
Mm-hmm. All right. Let's see. The court should categorically reject this maneuver. California Family Code mandates that live in-person testimony be received at hearings absent a stipulation or a compelling showing of good cause. This is a substantive DVRO matter involving a restraining order where there has never been a finding of domestic violence, regarding material facts hotly in dispute, where Owens' credibility lies at the very heart of the case. Every factor enumerated in Rule 5.113 demands live testimony. Petitioner's motion attempts to evade cross-examination and continue her criminal pattern of deceit without judicial scrutiny, hoping her written narrative will escape the crucible of truth testing. Owens' documented history of perjury and forged evidence invalidates her pleadings. Her claims must be tested under cross-examination. The court should deny petitioner's motion, requiring her hearing on renewal to proceed as an evidentiary hearing with live testimony. In addition, respondent Mike Marraccini requests that the court impose appropriate sanctions for Owens' abusive process and refer this matter to the district attorney for investigation of potential criminal conduct. Okay. Including witness intimidation and offering false evidence again.
Nice.
Yeah, so this thing, like, with the cross-exam, she doesn't have a lawyer right now. I don't see how she's going to get one, really, unless she actually does have some crazy anonymous family member who's paying for everything, which I honestly, like, still, given everything that we know, like, who would take her case and, like, allow her to proceed forward the way that she is right now, knowing that, like, there's a lot that's not true in what she's saying. So I don't know if she's gonna, like, I want to say she won't drop it just because that's her pattern, but at the same time, how do you like, if you're Laura, how do you not just, like, run away from this possibility of cross-examination on this, knowing that you're already under, you have a bunch of criminal charges in Arizona.
Yeah.
Now you might get them in California. Like, I don't know. Can you be that dumb?
On one hand, she waited and dropped this harassment case against Dave Neal at the last second, because it was clear that wasn't going to go anywhere.
She did make him sign something, though. She always gets something.
Well, I mean, he didn't agree to do something he wasn't already doing. So
no, absolutely not. I know there's nothing, like, important about what she signed, but she still felt that she won in some regard, that she got him to make him do something, even though the thing that she made him do was absolutely useless and pointless.
Yeah, I mean, if you want to make me sign a form saying I'm not going to do advanced gymnastics, I'll sign it, because I wasn't going to do any advanced gymnastics anyway. You know what I mean? Like, but yeah, so it's sort of a non sequitur or something, or pointless. But on On the flip side, she did proceed all the way through the Clayton case and with the appeals, and
She was given a chance to walk away. They
everything
told her
she's
to just walk
everything
away.
she wrote before her lawyer told her to stop writing things says that she intends to fight these criminal charges, which, it's one thing when you're in family court and you're just arguing about whether you should get a restraining order or whether you're pregnant or whatever these things are in family court. Criminal court, I mean, you can go to prison. This is not a trivial repercussion for your actions, right? So that makes me think she won't drop this DVRO renewal. But I mean, I don't know. Anything can happen. I think, the argument here is very good because you really need to have live testimony, cross-examination. You need to spend a good amount of time on it because we're talking about an interstate lifetime DVRO. This has serious impacts on somebody's ability to live their life. You get harassed at airports, you can't purchase a firearm. There's all sorts of people, they don't take your job applications seriously, or they pass them over because they're biased or something. This has lifetime implications. So this judge, this isn't like a temporary thing where you're like, okay, we'll just keep everyone safe for a little bit until we can figure it out. This is the real deal. This is it. This is where we got to figure it out.
Yeah. Let me ask you a question. If you were Dave and you were put in the situation that he was in, not like you're not actually Dave, but say you're in a similar circumstance where she has accused you of this thing and is trying to get a restraining order against you, and you're like, there's no way she's going to win that, but she says she'll drop it if you sign this piece of paper saying you won't harass her. You would do it?
I think Dave did the right thing, and I think that was in consultation with his own attorney, and I think Dave had a good attorney for his case.
Well, Dave's got a wife and a kid on the way at that point and all this stuff, and so of course he's gonna, that's what I would do too in that situation. But I'm saying, you as Bruce, what would you do?
What? Wait, I'm not Dave anymore?
No, you're not Dave. You're in Dave's situation, but
if
you
I was
Bruce.
Dave, the first thing I'd do is I'd take a bunch of selfies with my cool hair. That's the first thing I'd do. I mean,
no, but they were like, they just moved. He had a wife and a baby on the way, and so I'm wondering though, in your situation, like you as Bruce, if you're just in the exact same circumstances, what do you do?
Oh my gosh. I mean, 100% I would consult with my lawyer, my legal counsel on the trade-offs, right?
Yeah.
If you hadn't just bought a house, if you were single and if you didn't have a lot to lose, yeah, there's a little bit more pushing you towards like, I'm just going to fight this bogus.
Yeah.
Which is what we saw in the Clayton case, right? Clayton is out there and he's like, oh, you want to drop this because you claim you miscarried? Sorry, I filed a response. Therefore, the case doesn't have to close because I will file motions for sanctions and fees at a minimum. And if, if there was no avenue under Rule 25 in Arizona for sanctions and fees, Gingras is actually correct. He could have filed a defamation case. I think Clayton has the best defamation case of all three victims because of the Chase J. Jones stuff, because of the contact Laura made to that speaking engagement company. That's a much clearer defamation case.
Yeah.
From my point of view. So, Clayton was in a position where it's like, look, we can't let this go on. There's other guys. I need to see this through because it's not just me I'm fighting for, it's other people. So I don't know. I still think Dave did the right thing.
And I do think that what he did obviously was the best outcome for him, ended up with the best outcome for him. Obviously he had good legal representation and all that.
Yeah.
But this is kind of what I'm getting at here. Ikimbo says, look how well signing a document agreeing to what you were already not doing worked out for Justin Baldoni. So that's kind of where I'm wondering, like, with people like this, with super manipulative people who love to cry wolf, cry harassment, whatever, where it didn't happen, like, you got to make a choice there, and it's like harder than it should be.
Yeah, the thing is, I think the difference though is that Dave had like 50 public YouTube videos or
Oh yeah,
more
yeah, exactly.
covering the case.
Uh-huh.
Whereas if you say, okay, what happened on the set of It Ends With Us? Like, I
Uh-huh.
wasn't there, you weren't there, I don't
Right.
know. It's just he said, she said.
The whole thing wasn't live
But
streamed.
if you sit there and you say, what the hell is Dave doing? Well, here are all of Dave's videos.
Right.
Here's all his email communication. Here's, Patreon where he's talking to Reality Steve. It's all just out there. So Dave's defense is all of his collateral product, right?
Mhm. Yeah.
Because she could say, oh, Dave Neal signed a thing
Right.
which proves he thought he was guilty of something. And then
Right.
Dave can say, just go watch my body of work. This is why she started removing his name from her Medium articles
Yep.
at some point,
Yep.
because people who didn't understand the case would read the Medium articles, see Dave Neal's name, go watch Dave's videos,
Right.
and change their mind. They might think, oh, this Clayton guy is probably a deadbeat. And then
Mhm.
they go read the court documents, watch the Dave videos, read the Medium articles, and
Right.
decide for themselves. And that's all Dave's ever wanted, is for people to look at everything and decide for themselves.
Mhm. I do think
So,
it's kind of
so the
interesting.
context is a little different than the movie, because the movie's
yeah,
kind
for
of
sure,
private
for sure.
enterprise, but it's a good counterpoint argument. If you're in that context, it is very sketchy. That's why
Right.
those guys that never should have signed that. What is that? That 15-point list or whatever. That's like,
Was it 17?
or whatever it was.
I already forgot, guys.
Lots of management problems in
Yeah,
that
somebody can tell us.
situation for that movie. 100%.
Yeah. So I guess it's just kind of interesting though when you look at the type of person who does this, and it's like when they have, there's no real cards for them to play. They'll kind of try to invent one, in the way that Laura did with that "I won't harass you" thing, and then Blake's 17-point list of stuff that we will not do this. Not saying that they had, but basically saying we will not do this, so that later, Laura, kept going to the point where she was in such a deep hole that she couldn't even do anything with that if she wanted to.
Yeah.
Um, but it's just interesting the way that they will kind of spin things and try to create something like that to use as a weapon. And it's sketchy as hell.
Yeah.
And it's always that type of person who like sees some sort of horrible like accusation or exploitation of some sort of serious issue, as a means to control people with this document that says I will not do this. Not as an admission that they have, but just so they could spin it that way.
Yeah,
like,
and there's
do this
trade-offs,
or
right?
else. Yep.
Yeah, like this whole no contest thing that Mike did originally with this DVRO didn't work very well. Right.
Yep.
So now they're having to explain it here in great detail,
Yep.
and work backwards, which means they have to do more heavy lifting now, because they made that decision back then. But it's a lot of this is Monday morning quarterbacking.
Mhm.
So, and I don't have the best fantasy football team, so what can you do?
Yeah, somebody says, "Can we move past the lively Baldoni stuff?" Guys, I'm gonna just like politely say, every now and then, if I see a commonality, I'm gonna talk about that. I mean, I'm gonna do what I want here. I mean, you don't have to watch. It's totally on you.
Yeah, I mean, there's parallels, and they might be different cases. We've talked about the Lori Vallow case a little bit. We've talked about other
Jackie with the 150,000 texts, like just sometimes there's
or
stuff that you want to
who's
bring
the
up or you
sports
notice
guy? There was another sports guy in Arizona who had fake pregnancy allegations.
Trevor
Bauer
Is that what you're
case.
talking about?
There's a lot of cases where you can compare and contrast. It can be interesting. Can be interesting.
Yeah. All right, let's get into this.
Mm-hmm.
Okay, live testimony is required by law in this contested DVRO hearing. And this is where I'm like, well, Omar's not with us, but we're going to do our best with this stuff. Under California law, live witness testimony is the rule, not the exception, at family law hearings involving restraining orders. Okay? Family Code Section 217A provides that at a hearing on any order to show cause or notice of motion, under the Family Code, absent the party's stipulation or a finding of good cause, the court shall receive any live competent testimony that is relevant and within the scope of the hearing. The statute reflects a strong legislative mandate favoring live testimony, so truth may be ascertained through examination rather than written declarations. If a court finds good cause to refuse live testimony, it must state its reasons on the record or in writing. California Rules of Court Rule 5.113 implements Section 217 by enumerating factors the court shall consider before denying live testimony. These factors include whether material facts are in controversy and whether live testimony is necessary for the court to assess the credibility of the parties or other witnesses. Each of those factors decisively favors live testimony here. Okay. So whether material facts are in controversy, that's, yeah, definitely. Whether live testimony is necessary for the court to assess the credibility, that's also a yes. I mean, yeah.
Yeah, and you can just imagine Gingras arguing against this whether material facts are in controversy argument, because he'll cook up all his reasons why he thinks everybody agrees with the basic facts of the case, right? That's what he would do.
Yeah.
I don't know what he would do about this credibility argument, though. That would be interesting.
I'm just thinking back to when she didn't know that she was being live recorded on the Zoom court, and she was like pounding back monster energies.
Oh boy,
what a genius! That was amazing.
I mean, yeah, that didn't engender a lot of credibility or trust with people who had gone through pregnancies before.
Right. Then again, she didn't know that she was being watched at that point, so it's like really interesting.
I think to me, I know Monsters because it's just so funny, right? But to me, the thing that ruined the credibility in that was she was standing for like 2.5 hours straight.
Oh God, yeah, that too.
And you know, people, even like MG Law, he's like, my wife could never stand up for 30 minutes, let alone 2.5 hours. Like, she'd want to sit down. A real pregnant person wouldn't do that. So to me, there's all these things,
right?
When you get eyes on it, and that's what the real, the live testimony, the being in person, that's what that lets you do as a judge, right?
Yeah,
lets you see all that.
Let's see. This is a contested DVRO renewal involving diametrically opposed accounts of past events, where virtually all material facts are in dispute. More importantly, credibility is paramount. Owens' case rests on her claims of fear and past abuse. This renewal hinges on whose narrative to believe. The California Evidence Code explicitly recognizes that in determining a witness's credibility, the fact finder may consider any matter that has any tendency in reason to prove or disprove the truthfulness of their testimony, including the witness's demeanor, character for honesty, and prior inconsistent statements. These credibility factors cannot be meaningfully evaluated on the cold paper record. A declarant's written words reveal nothing of her tone, hesitation, or eye contact, and they prevent the opposing party from probing inconsistencies in real time. But what about the hand signals? Are those still allowed? God damn it. All right. To assess the credibility of Owens, whose honesty is very much in question, that's a nice way to put it, the court must observe her live under oath and under cross-examination. I mean, that's going to be a bloodbath. Not literally, Laura. Please don't report me. California courts have consistently emphasized the importance of live testimony in contested matters, particularly in cases involving restraining orders or other significant issues where credibility and due process are at stake. The courts have condemned decisions based solely on written declarations without providing parties the opportunity to present live testimony, cross-examine witnesses, or otherwise fully participate in the proceedings.
Yeah. It is very important, I think, because she'll probably just reiterate. It's sort of like the June 10th hearing, right? She'll just reiterate her talking points.
Yeah.
And, the good thing is the judge will be able to see sort of the tone and the behavior, right? Like having a breakdown and demanding a break or whatever. I think cross-examination is critical because we kind of saw two different testimonies on June 10th, right? The direct examination and the cross-examination.
Right.
And the behavior and the demeanor was very different between those two.
Of the lawyers too.
Yeah. And that is where the cross-examination to me is the most important of these.
Mm-hmm. Yeah. Hope Johnson, thank you for the $10. Lauren, are you going to wear your Alcatraz pants to the hearing? Oh boy. I accidentally got a hole in them. So even if I wanted to, I couldn't. But I still wear them around my house. So but no, I would not wear that to court. I'm going to dress like a normal person going to the courthouse. So basically a Halloween costume for me. Let's see. Owens wants the court not only to consider issuing a permanent DVRO, but she desires criminal prosecution without ever hearing directly from either party in court. Granting such a request would violate the letter and spirit of Section 217 and Rule 5.113. It would almost certainly constitute reversible error as grave miscarriage of justice. Respondent intends to testify and present evidence after being properly noticed. and served to refute Owens' claims. He has a constitutional right to cross-examine Owens on the stand. Owens cannot unilaterally waive the presentation of live testimony when the other side demands it. In the absence of any stipulation, the court must take live testimony unless Owens shows specific good cause to refuse it, and as explained below, there is compelling cause to require Owens to appear and testify.
Very good.
Petitioner seeks to evade cross-examination as her claims cannot withstand scrutiny. Owens knows her narrative will collapse under cross-examination. Owens' goal is not convenience or efficiency, it is concealment. First, petitioner's professed reasons for avoiding live testimony, to the extent she articulates in any in her motion, do not hold water. Owens claims she feels traumatized or fearful of being in the same room as respondent, yet she stalked the shit out of him for I don't know how long. After obtaining the DVRO in 2018, Owens actively sought out contact with Marraccini, messaging him repeatedly, approaching his family, even traveling across the country to confront his employer with her allegations. In September 2024, this is 1 year ago, guys, while on a trip to New York, 1 year ago, after Clayton's trial, while on a trip to New York, Owens made an impromptu stop at Marraccini's employer's HR department to alert his employer that he had a DVRO issued against him.
That is wild. And
Yeah.
I don't think we've seen anything that clearly stated about this before.
No, we've gotten, it's been mentioned.
There's been some hints.
Very
but
vaguely.
This is the most detailed description of what happened there.
Yeah, so she was like actively stalking him up to a year ago, and maybe even after that, but we don't know about it. So
yeah, that's wild.
It's crazy as fuck. Oh, hey Steve, how's it going? Thanks. Yeah, it's so crazy, man. I mean, that's creepy, man. Like, how creepy is that?
That means you have to know where they work. That means you have to know, if it's some sort of global company, like where is the HR department? Like that's
and to,
a lot
go
of
in person,
and then go there.
Right.
Like that's bizarre.
Yeah. She gave a public TEDx talk in January 2022, describing herself as a domestic violence survivor and recounting her accusations against Marraccini. She authored a chicken soup essay, doing the same. In none of these very public forums did Owens exhibit the slightest hesitation about reliving her claims. No, she did not. Yet now, when it comes time to actually substantiate her accusations under oath, Owens suddenly shrinks back and pleads to do it on paper. Her newfound reluctance is not about emotional difficulty, it is about avoiding the exposure of lies.
Yeah.
Second, petitioner's procedural conduct shows a desire to ambush and silence respondent rather than a bona fide need for accommodation. She hadn't even served Marraccini with a renewal request or this motion, presumably hoping he might not appear at the August 1st hearing, allowing her narrative to go unchallenged. In a declaration, she can say whatever she wants, blatant falsehoods, without risk of immediate impeachment. Okay. And when they're citing the case stuff, I'm not going to get too much into that, but what is this, Norgard versus Norgard? Is that how you say that? California Court of Appeal reaffirmed that denying a party the right to testify or offer evidence is reversible per se. The court emphasized that family law judges must ensure a full and fair opportunity for parties to present all competent, relevant, and material evidence. Litigants have a fundamental right to testify and call witnesses, subject to reasonable limitations, such as excluding cumulative or unduly prejudicial evidence. All right. Owens bid to
or if Arizona doesn't allow her to leave the state. Because they need to get a hall pass from the principal first before she
I feel
can
like
go on.
I feel like the state is probably going to be like, yeah, go for it. I don't know. That's just me though.
Yeah, I mean, if I was an Arizona prosecutor, I'd be like, sure, go to California. Here's a shovel. Dig yourself a deeper hole.
Yeah.
We'll be watching. Yeah, 100%.
WTF in 2024 stalked Mike's job. Yeah, and she also, don't forget, she also called the police on all three of those men after the trial for appearing in court. Clayton. She called the police on Clayton.
I mean, that was
appearing in court.
That was just absurd. But this stalking thing in New York, this is breaking news. This is really beyond, because that's like physically going somewhere.
So crazy.
Going to a place you don't work.
Right.
That's just wild.
Yeah. I'm gonna guess she's not that scared of him, because like people would say, like, well, playing devil's advocate, somebody might say, well, he doesn't work in the HR department or whatever, so he maybe just not know about it. But obviously, like, if she's telling them that, she's expecting them to take action. He will find out about that. And if she was really afraid that he was a big, scary guy who was going to attack her or something, she would not be taking that risk. Sorry. That's not a thing. And I'm not saying that nobody should ever do that if you have somebody who has been like attacking you or whatever, but you don't go there in person to make a complaint, like to the place where he works to make a complaint, knowing that he's there and he might come and like if he was an actual person that like did any of the things that she ever described, might come and attack you or something like that. You're not going to do that, especially when you can just send an email, like a fucking email from anywhere in the world. Back when you're in Arizona, maybe. Obviously, you didn't have to go there and do that in person. The only motivation I can really conceivably, or I can really believe, I guess, is that she hoped that she might get a glimpse of him or something.
I think it's more like intimidation or
Maybe that too.
trying to get a rise out of someone. I mean, it's the exact same thing with these emails, where it's like emailing Clayton or emailing Dave Neal instead of calling the authorities, or because there's a true emergency, right?
Well, that would be like going to Clayton's office or to Dave's office if they had like office jobs, going to their office and talking to somebody, knowing that they would maybe be there instead of sending an email or making a phone call.
Yeah. I mean, if you really had something you wanted to get done, you'd talk to the correct authorities. Talking to, yeah, exactly. Karen's got it. How can HR at a job protect her? There's nothing she's trying to do.
Doesn't work at House of Prime Rip.
In terms of direct, like a goal, right? In order to, I'm in a problematic situation. I need to get out of it. What do I do? This is very analogous to like the email sent to Dave. Like the friend would have called the authorities, not sent an email to Dave if that situation were realistic, right? If you were in this situation, you wouldn't be like, oh, I just happen to be in New York. I'll just drop by this guy's HR department while I'm here. Like what?
Yeah, dude.
It's not solving a true problem. It's obtaining some sort of strange.
You weren't actually trying to do any good for anybody, including yourself.
Yeah, it's nefarious purposes, I think.
I mean, I try to be careful with saying somebody who is abused absolutely would or would not do XYZ, because I know how like things can go and how things can look. I mean, I've recently, shared some of that with you guys, but like I know some things that I have done or something that I've said, they're not necessarily sensible if you were like from the outside looking in. It's not like you would look at that and be like, well, why the fuck would you do that if you're, telling the truth about this? So like I know how that is, but at the same time, there's sometimes then there's such a reasonable alternative, and it'd be easier, safer, and more effective to do that. And there's just such a more reasonable alternative that I cannot believe, like rationally, that you would actually go and do what you did. And that's kind of what this feels like to me.
Well, there's also like you're saying, you may have done some things that weren't super rational at the time, but in hindsight, you can recognize the Monday morning quarterbacking. Maybe I shouldn't have done that. In this case, what do we have? We have a DVRO renewal for a lifetime renewal. So she's pushing hard. She's all in. There's no reflection here. There's no like, oh, maybe I shouldn't have done that.
Yeah. Right. I mean, we can get into all kinds of things regarding like how women will act around their abusers and why they might do certain things, but I guess we've kind of covered that, so we'll just move on. But
yeah,
it's just kind of crazy to me. It's so crazy. All right. Owen's bid to avoid testifying is an attempted end run around the truth-finding process established by basic due process. The last time Owen's claims were tested under cross-exam, she perjured herself to such a degree I'm sorry, that she is currently facing 33 years in prison in Arizona. That's beautiful.
The underline is just the cherry on top.
She perjured herself to such a degree that she's currently facing 33 years in prison in Arizona. She fails to represent in any of her filings there has been a judicial finding that she lied under oath and a looming criminal prosecution for perjury. A litigant who has demonstrated a propensity to lie cannot be given a pass to litigate via unsworn paper or unchecked declarations. Oh, God. All right. Petitioner's motion and renewal request are an abuse of process aimed at harassing and intimidating a witness. Owens is now a criminal defendant in Arizona. Respondent Marraccini is a material witness in that pending case. The state's disclosure explicitly lists Michael Marraccini as a witness in State versus Owens. Owens' aggressive pursuit of a renewed restraining order and her insistence on doing so via declaration appears calculated to harass and intimidate Marraccini in violation of Penal Code Section 136.1. This isn't the first time she's used this tactic. She already tried to have Marraccini arrested for violating the instant DVRO because he complied with a lawful subpoena where he was listed as a witness. She claimed his appearance by lawful subpoena was the basis for her renewal. She failed to represent to the court Mike was complying with a lawful subpoena. I mean, God. Owens is dragging Marraccini back into court on baseless allegations to obtain an order that would paint him as an abuser forever. Owens sends a clear message: if you cooperate with law enforcement against me, I will continue to make your life hell in court. This raises the specter of witness intimidation. The timing is suspect. Owens left the prior 5-year DVRO renewal run its course until just weeks after she was indicted and officially learned that Marraccini could testify about her past lies. Then she suddenly moved to extend the DVRO, which was about to expire, and concurrently sought to eliminate live testimony at the hearing. The inference is unmistakable. Owens wants to discredit Marraccini and undermine his standing as a witness against her. This is an outrageous perversion of the DVPA. The DVRO system is meant to protect victims, not to be wielded as a litigation weapon against someone who might testify in another proceeding. Courts have repeatedly warned against using restraining orders as tactical weapons rather than shields. Granting Owens renewal on the manufactured premise of continued fear would reward her misuse of the system and tacitly endorse a form of legal bullying. Ugh. All right. Owens failed to disclose. Oh my God. Owens failed to disclose she might not be able to give live testimony as she is barred from leaving the state of Arizona due to her felony indictment. I mean, who thought it was a good idea to just leave that out?
It's just some red tape, Lauren. I mean, we can.
I mean, I don't know, but honestly though, like, why think that's a good idea to leave that out? I don't know. I just feel like.
Well, you know, it's just a small matter of some paperwork. I mean, it's not like going to the DMV or something. Gee whiz.
All right. Well, Owens is currently subject to an order of release from Maricopa County Superior Court, Arizona, in connection with 7 felony charges, including perjury, forgery, and evidence tampering arising directly from fabricated claims, nearly identical to those she is now asserting here. Standard conditions of such order of release, or is that what that means? Or releases generally prohibit defendants from leaving the state absent explicit judicial permission. Owens' physical appearance. What's up?
Its own recognizance.
Oh, duh.
So she doesn't have to be in jail before her trial. She's out in the world.
Yeah, I gotcha. Well, that's a disappointment, but yeah. Okay. Let's see. Owens' physical appearance in California to participate in a contested evidentiary hearing requires prior approval from the Arizona Criminal Court. To seek that approval, she'd have to alert the criminal court that she's currently engaged in the same criminal behavior that she is facing 33 years in state prison for in Arizona. The underlying facts of this case necessarily form part of the foundation for the criminal case against her in Arizona. All right. The Arizona indictment is related to Owens' history of fabricating evidence and submitting false statements under oath. To participate live in these proceedings, Owens will have to convince the Arizona criminal courts to travel out of state so she can participate in a proceeding to continue criminal conduct that gave rise to her felony charges. It is exceedingly unlikely that the Arizona court will authorize such travel. Damn, I didn't know that.
Oh, that's too bad.
I'm actually kind of disappointed.
I know.
Wait, what are they doing?
Let her go get on the stand. I want to see it. I mean,
I do too,
let her
man.
make her case. Like, I want to be convinced, and so far I'm not. But I would like to be, given the opportunity to try to be convinced by her testimony on the stand in this DVRO renewal.
Yeah,
I don't know. I think it's an interesting argument. Like, why does she keep doing this if she's already in trouble over here in Arizona? She's trying to get in the same trouble in California. It's like, you never get the Girl Scout cookies, and they come in those sleeves or whatever of the plastic.
Yeah, I know about the Girl Scout cookies.
And you have one, and it's like you open one, you're gonna have like 4 cookies, and then the sleeve is gone, and you're wait, what happened?
I used to sell them. I know how that goes.
That's what happens to me. Because my buddy at work, he would get them, but he couldn't have the gluten, so he would give them to me, and so I would just like eat them at work, and they would just disappear. Right? That's how she is with these cases. They're like Girl Scout cookies to her.
Mm.
I don't know if that's a good analogy or not.
I think it's good enough. I mean, I think we can all relate to that. Let's see. This continued criminal conduct should be referred to the local district attorney for criminal prosecution, as Owens' behavior continues to put individuals at risk of further victimization. This court should not implicitly endorse Owens' attempted evasion of her own recognizance, is that what you call it? Conditions, by allowing her to proceed on paper alone. Okay. Additionally, this court cannot ignore Owens' documented record of dishonesty, forgery, and perjury. Given this context, permitting Owens to avoid live testimony would be extraordinarily prejudicial. Her declarations, unchecked by immediate cross-examination, would shield her from confronting demonstrable contradictions and fabrications. Moreover, given her OR conditions, Owens' ability even to physically appear at the hearing in California is doubtful without judicial authorization from Arizona, authorization that no responsible court would likely grant under these circumstances. I mean, damn, I didn't even know that. All right, motion to seal should be denied. Well, yeah. I mean, I'm not gonna not to encourage anyone, but I feel like I would like a full written apology from this weirdo for including my picture in her filing when she asked for sealing. No pressure, guys.
I was in there too. Oh my gosh, that's crazy.
Oh, that's right. She had a picture of both of us.
I know, we were both in there.
What a fucking weirdo! God.
You know, I'm interested to see how he's going to conclude in terms of what he wants here, because on one hand he's saying this is opposition to proceeding by declaration, and on the other hand he's saying there's no way the court is going to let her go to California.
Yeah,
maybe he just wants a Zoom thing or something. I don't know.
Would they do that?
Would that be? We'll see what he wants at the end. Maybe.
Is Monster Energy allowed?
Yeah, why not? I mean,
in the Zoom hearing?
Sure.
I mean, dude, it's just not the same, I feel like, without having her face to face with somebody crossing her. And then, like, also think about, like, how they did it with the hand signals last time. Like, you're going to have to show the room just to make sure there's no one behind the camera giving baseball signs. Jesus Christ. What a mess.
I mean, it's tough, and it's got to be tough. Like, if she does hire another attorney, it'll be tough for them if they're all over Zoom. Because if you remember, it was original Josh 1.0, when they were on Zoom, right? And you could tell he was just like, when the judge was admonishing Laura for speaking out of turn, you could see he was a little frustrated because there was nothing he could do. He couldn't talk to her or whisper to her or do anything. Right. Yeah, it'll be tough. Yeah.
Let's see. I want to see her stammer and throw a fit on the stand about JFC. Yeah. Right. There was another thing here that I saw that I wanted to bring up, but I can't remember what it was now. Okay. Owens' bid to seal the proceedings conflicts with California's strong presumption of open courts, as court records and hearings are presumptively public under California law. California Rules of Court explicitly states that court records are presumed open unless confidentiality is required by law. This principle is rooted in the public's First Amendment right to access court records, as articulated in NBC Subsidiary Inc. versus Superior Court. I'm not going to read all that. Under Rule 2.550D, a trial court may order a record sealed only if it makes express factual findings that 1. There exists an overriding interest that overcomes the right of public access. 2. The overriding interest supports sealing the record. 3. A substantial probability exists that the overriding interest will be prejudiced if the record is not sealed. 4. The proposed sealing is narrowly tailored. And 5. No less restrictive means exist to achieve the overriding interest. I'm sorry, I didn't see anything about fake autism in there. Did you?
No, I mean, these are very strict rules.
I'm looking for the part about the fake autism that would excuse this, and I just can't find it.
Is that why she wanted to seal it?
That and her anorexia or something. Nobody's requiring you to eat. Just show up and
So So here's the thing. It's just like the February status conference that we had in the Clayton case.
Mm-hmm.
If there are specific medical diagnostics that come into play here that Omar can receive from a provider directly,
Right.
you could seal some of those things while having everything else be part
You
of the
could,
public
but she would
record.
already have given the press her patient portal login, so why would you?
I mean,
God damn it.
I mean, the problem with that in the Clayton case was that she didn't have any real OBGYN results, right? You know,
Sure she did.
there were no determinate Ravgen paternity results. Like it was just like a dearth
Yeah.
of evidence.
Yeah.
So, you know, I totally understand it. This makes sense. If you narrowly tailor, like, okay, here's a doctor who has an anorexia diagnosis, and there's details about that in some report
Mm-hmm.
that aren't totally related to the DVRO details or the petition, then seal them and just give them to Omar. I mean, that's fine, right? But
Yeah.
you have to follow all 4 of these items, and that is a high bar, is what he's pointing out.
Yeah.
There's a high bar here for the items. You can't just seal the entire case, because what she really wants is, like when she was sending emails to Dave Neal saying, oh, this old case was totally sealed. You can't talk about it or see anything, or you shouldn't be able to see anything. And it's like, no, that's not correct. So he's just pointing out the correct rules here, which is good.
Okay. These stringent requirements codify constitutional standards and make clear that sealing is the rare exception, not the rule. Petitioner has not come close to meeting this heavy burden. She identifies no overriding interest sufficient to overcome the fundamental presumption of open access. Her claimed basis for secrecy is not the protection of any legitimate privacy interest, but rather an effort to shield herself from public scrutiny, avoid embarrassment from challenges to her credibility, and prevent the public from observing her ongoing criminal conduct. Avoiding personal embarrassment and reputational damage while concealing criminal conduct is not a valid ground for sealing under California law. Owens has actively publicized the very allegations at issue in this case. By her own account, petitioner has openly discussed her relationship and abuse claims in public forums, including a TEDx talk in January 2022, describing how a note from a stranger prompted her to leave an abusive boyfriend, a reference to respondent. She has published essays and made media appearances touting her status as a domestic violence survivor, voluntarily disclosing details of the alleged abuse. She also initiated prior litigation in 2018, a domestic violence restraining order case, based on these allegations, which was heard in open court and resulted in public court records. Having freely injected her story into the public sphere, petitioner cannot now credibly claim a compelling privacy interest in shielding the same narrative from public view. Owens has painted respondent as an abuser in the court of public opinion through interviews, online posts, and public talks. Yet she now seeks to close the courtroom doors and keep the actual evidence and testimony hidden from the same public. This one-sided use of secrecy would severely hamper respondent's ability to clear his name. Fundamental fairness dictates that respondent be allowed to rebut petitioner's allegations in an open forum so that the truth can emerge. The California rules recognize that transparency is crucial not only for public confidence in the courts, but also for the integrity of the fact-finding process. Petitioner's attempt to seal the record is an effort to control the narrative and avoid having her claims tested under the glare of public scrutiny. The court should emphatically reject this request. So, I mean, she thinks that she's like very special for some reason, that her problems that most of them are made up, are like so special that nobody should be able to like see what she's saying when she knows that she's saying things that are not true. That doesn't work. Like there are much more important cases where they don't get these things sealed. So I don't know why she thinks that she's so fucking special, even though she keeps trying and trying and trying and getting denied on this.
It's this bold part, controlling the narrative, right? It's a double standard. She wants, if it's good for her, she wants it to be publicly available. If it's not good for her, she wants it to go away or be silent. This reminds me exactly of this email she sent to all these podcasters early on in the Clayton case, saying, hey, if you cover this story and you agree with Dave Neal, or you agree with Clayton, or you take Clayton's side, I'm going to sue you for defamation.
Yeah.
Which is just, no, you can't do that to journalists.
Well, she
That's
also sent a somewhat
absurd.
similar email to opposing counsel in this case. So
Yeah, I
you know,
mean, it's
fucking
all the
awesome.
same playbook over and over again. We're just
So
seeing it.
stupid.
And the thing is, Omar has to be he has to go through and have this big section here that explains it in a very detailed way, because we know the backstory. We can see this playbook happen over and over again, the pattern.
Yeah.
But a judge who's coming onto this case is not going to have the same background on these cases that we do. So he has to do a good job explaining it here.
Mm-hmm. Yeah. You see, Steve, thank you for the $2. Lauren, thanks to you and Bruce for jumping on this. Oh, thanks, Steve, for all your help. Steve went down to the courthouse and got some of this stuff for me last week and the week before. He got it for all of us, so that was pretty cool.
The real hero.
Yeah, right. Rage G, thank you for the $5. Domestic violence victim by a sex offender. I contacted management and authorities to keep others safe. Never once thought about going to his place of employment. Yeah, that makes sense. And I'm sorry that you had to deal with that. Thank you for sharing that with us. Let's see. She wants to avoid accountability, perjury, and looking like a dumbass. Yeah. Maybe she'll do another crying video on Facebook. Who knows? All right. Let's see. Relief requested, evidentiary hearing, sanctions for bad faith, and referral for
to my closest friends. My name is Bruce the Moose.
What? I'm sorry, what?
Like, remember she did that Facebook video and it was like she made it friends only or whatever, but then
okay,
she's
so
like, my name
is
Laura Owens. Like, what do you need to tell your friends page that your name?
I don't think she has any friends, man.
Yeah, but I mean, just in general,
I know what you mean.
It's just
so
goofy.
crazy. Yeah,
crazy.
I barely could sit through that once. Barely could sit through that once. So there's a lot I don't remember from what she said there. I just remember the fake crying, which was amazing. Like, no tears, very red face from straining, and it's just pathetic.
The only way I could really get through it is Reality Steve did one of his podcasts where he goes through the audio of that video and pauses it and responds to like each sentence, so that it's not all in all. It's because if you just play it, it's like this big onslaught. It's hard to listen to.
Cringing.
But if you let Steve pause it and refute, like, no, I sent you this email, or she says, Dave made 50 videos, and Steve says, well, he should have made 75. That was one of my favorites. Yeah.
God. No, she'll complain about how many videos each of us has made or whatever, and I'm like, well, babe, I make a new video every time you write a Medium article, so if you want it to stop, maybe just chill out.
Yeah. It's just, that's part of the public discourse. It's normal conversation.
I mean, nothing about this is normal, but okay.
Well, in general, I mean, in terms of covering cases or stories or topics of interest.
I know what you mean. Yeah.
Oh boy.
Okay. 1, deny petitioner's motion to proceed by declaration and order that the hearing go forward with live testimony after proper service has been effectuated. Both parties and any other permitted witnesses should be ordered to testify under oath, subject to cross-examination. All right. 2, deny petitioner's motion to seal. Petitioner has not met the stringent criteria of rules 2.550 and 551, and the First Amendment and common law rights of public access would be unjustifiably infringed by the blanket secrecy she seeks. 3, impose sanctions on petitioner for bad faith litigation conduct. Owens' litigation tactics, including failing to serve her opponent, attempting to mislead the court, and persisting in claims known to be false, have needlessly increased the cost of this litigation and undermined the policy of cooperative resolution. 4, refer petitioner's conduct to the district attorney for possible criminal investigation. The evidence before this court suggests that Owens' actions are not merely civilly actionable, but criminal. The court should consider making a formal referral or recommendation to the San Francisco District Attorney's Office to investigate Owens for perjury, offering false evidence, and witness intimidation, among any other applicable offenses. Conclusion, Respondent Michael Marraccini respectfully urged the court to deny petitioner's motion to proceed by declaration and to order that the matter proceed with live testimony pursuant to Family Code Section 217. Furthermore, Respondent asks the court to send a clear message by imposing sanctions on Owens for her bad faith litigation conduct and by referring the evidence of her perjury and intimidation attempts to the district attorney. Owens' ongoing insidious manipulation of legal processes must end. Okay. And then there's Omar's.
Yeah.
Guys, tomorrow is Omar's birthday.
Oh, happy birthday, Omar.
Yeah, he deleted all his social media, but I don't know. I don't want to let him get away with
He's
having
working
no
hard.
attention. So I
Maybe
think,
he'll watch this video and we can say happy birthday.
I mean, we can, but to be honest, he's kind of ADD like that, so I don't know if he'll really hear it.
He might not watch all the way to the end.
No, probably not. I'm gonna doubt it.
We can sing the happy birthday song. Happy birthday to you. You smell like a shoe. What is it? How's
Shoe.
it go?
That's a nice way to
Yeah,
put it.
a
You
shoe.
smell like a shoe. Okay. Well, I
You
think that
look
probably
like I don't know. Oh,
something that rhymes with shoe.
you look like dirty laundry and you smell like one too. How's that go? I don't know.
Fuck, I
Anyway,
forgot. Anyone in the chat? You guys know?
a zoo.
Oh, a zoo. You smell like a
Thank
zoo.
you. Yeah, there it is.
And what's the last line?
I don't know.
Ah.
Oh, you look like a monkey and smell like one too. Okay, maybe there was no
Oh.
shoe. Maybe it was always a zoo.
You made up the shoe?
Well, Omar says I have a foot fetish, so
Oh god. Jermaine Down, thank you for the $5. What's the over under that Hello has already filed a bar complaint against Omar for delivering that legal butt whooping? Dude, I don't
yeah.
know. I think there's a pretty good chance that she has. I don't know.
Good luck. I mean, if you go back, what was it, number 1 through 4 up above? We don't need the exhibits, do we?
What are we looking at? No, we're not going to read those because they're
1 through 4 is what he's asking for. So this
Yeah.
is, number 1. And number 1 was denying to proceed by declaration. So he doesn't get into super detail, but he just says, well, he says live testimony. He doesn't say in person. So I guess Zoom is
Right.
good enough here. Because obviously, if Arizona says you can't go to California, there's
Yeah.
no alternative.
I mean, I would highly prefer she be able to go, obviously, but
and what? Laura can sell your feet pics to Bruce. What? Oh dear.
Ew.
Anyway, that's one way to get out of bankruptcy, I guess.
Yeah, right, sure.
The thing I think that's really interesting here that Omar's done that I did not expect is we knew about like the bar complaints in terms of witness intimidation about Gingras for June 10th.
Yeah, right.
And he brought that up in his motion to disqualify Gingras, right? But he's actually connected the dots here, which I think is kind of brilliant in terms of looking at the filings or the petitions that Laura's made in this DVRO case and saying these filings themselves and the way she's doing it is itself potentially witness intimidation and should be investigated.
Yeah.
Not just Gingras, but also Laura, because they're playing out of the same playbook.
Yeah.
In terms of what they want. And I think that's really something unique about this filing that I really like.
Yeah, for sure. Big Farts 69420 says the only complaint against Omar should be that his voice is too silky. Okay.
I know, too sexy. What can we do?
I used to like fall asleep if I was trying to listen to Omar's videos when I was just like late at night. And now I just want to argue with him all the time, so I can't.
I want to cross-examine Omar on his filings, but I can't. But yeah, it's a good time. And this thing, what is it? It's about 14 pages for this motion before we get to the exhibits.
13. So
it's good. It's comprehensive because obviously we know if you're writing this motion for you or me, you could do it in a few pages. But for a judge, you got to do the whole detail and context and everything, but you don't want to take it too far. So I think he's got the right length here. Echoes from Tabernacle says he appreciates the conciseness, and I agree.
Oh, somebody just gave me an idea. It was Teresa. Teresa says, yeah, he should give us a filing for his birthday. She just gave me an idea.
Motion to compel cake.
Don't give it away, Bruce.
Oh, okay. I don't know. That's what I want.
Something along those lines. I'm just going to email it to him. It'll be like the most ridiculous thing he's ever seen.
Maybe a cupcake. Because sometimes the whole cake, like it's too much. You cut it and then it goes stale. Or you get cupcakes.
I'm going to think of something so fucking ridiculous and just put it on this pleading paper and I'm going to send it to him tomorrow.
Oh, boy. There you go.
In lieu of a birthday card. It's just something stupid as fuck.
Amazing.
All right. I'll show you later. All right. Guys, I think that's all I got in me for tonight. It's almost 11 p.m. here, and well, I'm trying to go to bed earlier these days. Also, something weird. I haven't told anyone about this yet. I got home on Saturday night, like almost midnight, and I was thinking about going to Vegas today, actually for Perez's hearing, and then I was like, I have to leave town again on Monday. And then I got home, and my mom just like casually drops on me. She was like, "Yeah, by the way, somebody fired a gun into our office. And I was just like, excuse me? Excuse me? What did you just say? And she's like, somebody fired a gun into our office. She shows me a video. This guy comes up in broad daylight to their office. Nobody answers the door. He gets mad. So he shoots a bullet into the door. It's the most bizarre thing ever.
Wait, where did this happen?
My parents' office just down the street.
Like, what is this? Like a business?
Yeah, they run a psychology practice.
Is it at their house?
No, it's not at their house. They have an office like right down the street from my house.
Oh, okay. So it's like one of these leased professional
So I was
buildings
like,
or whatever.
yeah, so I was about to be out of town again
Yeah.
in Vegas, and then I was like, well, I don't think I really want to go anywhere right now.
Yeah.
Because what the fuck? And
Wait,
still
did
don't
they
have,
know who this person is or why they did this?
they caught him because he also tried to shoot up the electric company. And so they caught him. He's in custody. I think he's still in jail, hopefully, but they don't know the connection yet or like the motive yet.
Was
But
this, I mean, maybe they can't say, but was this a customer of theirs or?
I don't think they can't say that. Is
Yeah.
the thing. So like I can't ask that because they can't.
So
tell
we
me.
don't know.
Right. So like
Okay.
the police, they gave them a name. I don't know it, but they gave them a name, and I guess they can look at their records and find out if there's a connection, like to their,
Sure.
because they do like anger management groups and stuff like that with like the violent offenders from the state or the city and all that stuff.
Yeah,
So
yeah.
so that was crazy. So yeah, anyways, here I am now, home for a while on East Coast time, and it is 11 o'clock. So I kind of miss being on West Coast time. I'm not gonna lie, because it always felt earlier in the night. But yeah, that's my life these days. So I guess I'm not leaving town for a little bit. Next time I go out of town will probably be if this trial happens. I'll go.
Well, I mean, the only relief there is that it doesn't seem like it was 100% targeted at you or your family.
Yeah,
Right.
I mean,
So,
maybe just people he's mad at. I don't know, because like you said,
yeah.
he went there first, and then I guess he went to the electric company and just shot up the electric company building. So I don't know, man.
Well, I mean, I don't know about the electric company, but it sounds like everybody's safe or nobody got hurt or.
Yeah, well, so my mom is sometimes in the office on the weekends, but she wasn't this time.
Yeah.
I don't know if that's why he got mad or what, but like he was mad that nobody answered the door, so he shot one bullet into the door, the glass shattered, and then he left. So it was
So he
very
didn't
strange.
even go in.
No.
Oh,
It's very
boy.
odd.
Yeah, I'm glad everybody's safe. That's yeah, that's not a
Right.
healthy coping mechanism.
No, certainly
Friends.
not. Yeah. Well,
Oh boy.
I mean, eventually it'll, be a thing that I joke about because his gun was so small, but like that's it. So. Bye, guys. By the way, my family is targeted by gun violence.
Yeah, you kind of buried the lead on that, Lauren. I don't know.
Yeah, no, I was just trying to explain why I'm like at home now, rather than because I was supposed to be somewhere else. So
Yeah.
I didn't make it to Perez's hearing today. Yeah, that sucked. But anyways, I better go to bed since I am here where it's late at night. So thanks, everyone.
Very good.
Please lock your doors and don't get shot. See you later.
Stay safe.
Yeah, that's what I meant to say. Right. Bye.